Intellectual Property's Western Views, a presentation by Group 16. Intellectual property refers to the legal rights which result from intellectual activity in the industrial, scientific, literary, and artistic fields. If you create something new and unique using your mind, you can gain respected rights to profit from your ideas. In order to protect the creators from having their intangible assets stolen, intellectual property laws exist in many of the Western nations and around the world. These laws are designed to protect creators by granting them the ability to control how their creations are used during a set time. Intellectual property can be broken down into two main categories, the first of which is industrial property. Industrial property includes inventions and industrial designs, as well as trademarks and other aesthetic designations. Intellectual property rights on inventions are usually considered patents. The other type of intellectual property is called copyright. Literally, artistic and scientific works belong to this category. Copyright exists in order to allow the copyright holder to profit off of their artistic creations. So how did it all begin? The earliest incarnation of intellectual property law comes from pre-colonial Britain. The Statute of Anne, enacted in 1710, gave authors the exclusive rights to their original work for 14 years, with an option to renew their monopoly for an additional 14 years. This legislation proved to be the foundation for copyright in the Western world. The Second United States Congress passed the Copyright Act of 1790, which was a near verbatim copy of the Statute of Anne. Copyright in the United States followed the same format for almost 2 centuries, with occasional increases in the term of either the original copyright or the renewal, eventually reaching a total combined length of 56 years. Copyright entered the modern era in 1976 when Congress extended the length of copyright to 75 years. These new terms greatly benefited publishers, production companies, and other corporate entities. With the Sani Bono Copyright Term Extension Act in 1998, the United States established its current term lengths of life of the author plus 70 years, or for corporate copyrights, 95 to 120 years. Unlike copyright laws, patent laws have retained much of its original form in the United States. The current maximum term for patent stands at 20 years. Some contemporary concerns involving Western IPs are that current IP views can prevent the flow of information, and there are some flaws that can lead to unintended uses. One concern is that IPs create information monopolies using blanket patents. What these blanket patents do is it excludes anybody else from using the patented information, which can slow down innovation. The other major concern with current Western IP laws is that it allows for patent trolls to exist, a person or company who enforces their patents but do not use their patent to manufacture something. Also, since patent trolls try to essentially extort money from other individuals by filing lawsuits against them, other people might get too intimidated to create new IPs since they might get sued. Though patent trolls don't affect large companies too much, small businesses could be driven out of business since litigation costs can be very high. This creates controversies. Many entities take the power of their IPs too far. For instance, in the year 2000, the RIAA sued over 30,000 individuals for copyright infringement because they illegally downloaded and shared copyrighted songs on peer-to-peer networks. Users were sued for damages in the range of $3,500 to $150,000 per song. In one famous case, defendant Jamie Thomas Rassett was ordered to pay $1.92 million in damages for sharing music. These lawsuits were responses to the rise of peer-to-peer networks, which lets users share lossless copies of music online, which understandably caused worry among content providers. However, the lawsuits were clearly overblown. Finally, content-producing unions have lobbied for more copyright laws online. The most famous example of this occurred last year with the introduction of SOPA, the Stop Online Piracy Act. This led to huge internet protests, including several large, high-profile companies creating a petition to stop the bill. Several content creators also stood against SOPA, just like this one.
This is Mike Mozart of Jeepers Media on YouTube, and I've got a secret. It's a deep, dark secret. I'm telling you, you're going to be one of the first to find out. You know this SOPA law they're trying to pass, Stop Online Piracy? Well, guess what? The same people that are trying to get the law passed and have put up like $100 million in lobbying costs to get this law passed so they can control the internet are the same people that distributed the file-sharing software. That's right. They're the ones that actually profited from the distribution of the software and taught people how to use it and then turned around and sued people like you.
But like always, there's a flip side. IP-intensive industries employ over 55 million Americans and hundreds of millions of people worldwide. The average salary in IP-intensive industries is about $50,000 per worker compared to the national average of $38,000. Enforced IP rights ensure products are authentic and of the high quality that consumers recognize and expect. IP rights foster the confidence and ease of mind that consumers demand and markets rely on, thus helping consumers make an educated choice about the safety, reliability, and effectiveness of their purchases. Look, downloading pirated songs from the internet is cool, but dying from counterfeit medicine is not. With all that, I want to leave you with one question. Can information be owned?